So perhaps the most confusing concept about employment law is the concept of employment at will. And there's really not a lot of magic to it. In Texas, and in most cases, I'm almost sure it's up to 45 states by now, an employer can terminate an employee for a good reason, a bad reason, or no reason at all. That's the employment at will doctrine. On the other side of that, on the flip side, an employee can terminate his employment for a good reason, or bad reason, or no reason at all. But there are exceptions. The exceptions are statutory exceptions like discrimination. In Texas, you can't fire somebody for the sole reason that he or she refuses to perform an illegal act. That's called the Sabine Pilot exception to the employment at will doctrine. There are many whistleblower statutes out there. There are statutes and regulations and case law to get around the employment at will doctrine. But the employment at will doctrine essentially says, as I said, you can fire or quit for good reason, a bad reason, or no reason at all. To add one point to the employment at will doctrine, which is very, very well misunderstood, a lot of people will have the understanding that Texas is what's called a right to work state, and that gets confused with the employment at will doctrine. The right to work state only deals with if the employer is a union shop. The employee can work there whether he or she is a member of the union or not. You have a right to work at a union facility, at a union job, whether or not you're in that union. And that's what a right to work state is.